understanding at that time was that Wisconsin law prohibited you as a 17-year-old from possessing a pistol, but you could have an AR-15?
Yes.
What was that understanding based on?
The understanding was based on when we would go up north, it was me, Dominic, and my sister, and we were allowed to carry the rifles around, and the officers over there said it was fine.
I'm going to move to strike as hearsay. What officers would have told
You
me.
asked the question of what the source of his knowledge was. It's not admissible, and none of this is, frankly, and that's why I interrupted before. What the defendant believes the law to be, what the district attorney believes the law to be, what the defense believes the law to be, are irrelevant. I will tell you, when I instruct you, what the law of Wisconsin is pertaining to the possession of a firearm by a person under 18, and that'll be the source of your knowledge. I'm allowing the testimony right now because it bears on there's an old maxim under the law, ignorantia juris non excusat. Ignorance of the law is not an excuse. Ignorance of the criminal law is not an excuse. If you commit a criminal act, whether you knew it was criminal or not, you're responsible for your conduct, and because you're responsible to know the law. It's not relevant, except in this case, there are specific issues about his awareness and knowledge about certain conduct that is relevant on some issues. So it's quite complicated. Hopefully it'll sort out when I instruct you at the end. But that's why I'm allowing the questions and the answers, but do not be confused about anything that these people say is not necessarily accurate as to the state of Wisconsin law. Any question about that? Okay, thanks. Go ahead.